It's live.
Okay. I have to get back to it. It's really funny because I haven't done this in a while. So I'm kind of like, am I pressing the right buttons? Okay.
I feel like I'm looking all over when I do it, like,
Yeah.
but it's live, it's streaming.
Okay, awesome. Let's, I'm going to share my screen. Is everybody else blocked? I'm sharing, yes. Okay, good. And then it was funny because I was like, how did Leona get in? Oh yeah, she's on logged into CPAC.
Yeah, I didn't mean to. I guess I didn't sign out. I meant to.
It doesn't, I mean, I don't know. I think, I'm not really sure if it matters or not, but anyway, here we are. Let's let people in because it's 3 o'clock, so I can go ahead and do that. And then while they're coming in, I'm going to share my screen. Hi, everybody. All
Hello.
right. Hi.
Hi.
So can everybody see the PowerPoint?
Yeah.
Yeah. Okay, good. Good. So good afternoon. My name is Beth Reel, and I'm here on our Zoom chat this afternoon to talk about transfer of rights. So what happens when your child turns 18? So I'm the executive co-director and transition coordinator at CPAC and Youth Advisory Board coordinator. And I wanted to hop on because we had a lot of questions about transition in our calls on Tuesdays and Thursdays. And so for the next couple of weeks anyway, we are going to share some different information. So this week we'll have transfer of rights, and next week we have Ruth Carvalho from the Bureau of Rehab Services who will talk about the Level Up program, because I know there have been some questions about that as well. So I'm just gonna go ahead and mute some people because I hear we're getting some background noise. So let's just jump right in here and then we'll get to some questions if the PowerPoint decides to work. There we go. So in Connecticut, as a student turns 18, all of their rights transfer to them. And so that is for all people, for all students, for all young adults, as they turn 18, all of their rights transfer to them. And so that's no different for students who receive special education services under IDEA, which is the Individuals with Disabilities Education Act. That's what that acronym means. And what that means is that student has the right to make all of their own decisions when it comes to school education and special education services, as well as financial decisions, where to live, medical decisions, all of those things. And what people get kind of confused about, I find often, is they think that, well, because my son or daughter has significant needs, that these rights don't transfer to that person. And unless in the very rare cases when a family may have guardianship before 18, which is very unusual, but does happen sometimes, unless a family has gone through that process for that person as they approach the age of 18 or as they're 18, then it does not matter what the student's disability is, those rights transfer to that person. And so many of you may know, and some of you may not know, that there are several things that can happen as a student turns 18. And so one, you'll see on the slide that I mention, unless the court has appointed a legal guardian or conservator, or other measures have been taken. And so legal guardianship is a process through the probate court, as is conservatorship, voluntary and involuntary. And there are several different levels of or types of guardianship. I'm not an attorney, so I'm not going to go into that or give advice on that. But, and I actually have reached out to someone who does presentations on guardianship, conservatorship, and legal rights as a person turns 18. So I hope to have that presentation maybe next month or in September. So we'll keep everybody posted on that. Some other measures that can be taken are things like power of attorney. There are healthcare proxies that can be put into place. So again, the person that we're hoping to have present in the future will have all of the specific details about all of those measures that can be put into place. One little thing I do like to say about guardianship is it's important to really consider whether that is the appropriate step, because there are a lot of alternatives for both guardianship and conservator. They tend to be more restrictive, and both guardianship and conservatorship require reporting to the probate court, financial information and things like that. And so not everybody wants to do that. But what's most important about these decisions is taking the person's individual situation into consideration. Sometimes guardianship and conservatorship are appropriate for people, and other times they are not. And so my suggestion is to get yourself informed before moving into these different processes, because they're not appropriate for every single person. And people throw around the word, oh, you have to get guardianship, or the phrase, you have to get guardianship for this person, very easily. And it's something that should not be taken very lightly. So at least 1 year before the student turns 18, the school district is supposed to notify both the student and the parents or the guardians that the rights of the student, of the family, transfer to the student when the student turns age 18. So usually that, I know some districts mail it out to people. I know other districts hand the information to families and students in PPT meetings. And so that's some information about that. So in Connecticut, back in 2013, there was some legislation that was put into place that says a child with a disability who has reached 18 years of age may notify in writing the Board of Education that the parent of such child shall continue to have the right to make educational decisions on behalf of such child, notwithstanding the facts that the child has turned 18 years of age. So what was happening prior to 2013 is there are many children, many students that don't necessarily require guardianship or conservator, but when they were in high school before the age of 18, or as they were turning 18, they weren't quite ready to make those decisions on their own. And so they really wanted their parents to help them. And honestly, most school districts are fine with that. Most school districts work with families, work with students, understand that the student may not be ready to make those decisions quite yet. But there were definitely school districts out there that were pushing back and saying that, no, the student has all of the rights now. Very rare cases where districts were holding PPT meetings without family members. They were pulling students who, at the age of 18, pulling students into PPT meetings and asking them to make decisions about graduation and things that were, really big decisions. And so the state, Connecticut, was really helpful in this way to bring this legislation in and put this legislation into place. And so what this means is the student can just very simply this paragraph in the middle that's in bold can write this very simple statement, or somebody can type it up and the student can sign just this really simple statement saying that they give permission for their parents or guardians to act on their behalf for educational decisions until such time as they graduate, exit from high school, or rescind the permission. So that's something that we suggest that families have students sign and give to not only the direct special education teacher, but ask that the statement be put into their permanent file, and they should update it every year. So this does not have to be notarized. We've had people, ask that question before. Do I have to have a notary, stamp this before I give it to the district? No, you do not. Simply, student can sign this, and the copies of this can be given to the important people and put in the file. So that's really the basic information on transfer of rights. And I will open it up to questions if people have questions, or if any of the CPAC staff want to bring in any more discussion about this. I just wanted to hop on and give some basic information about transfer of rights. So anybody, you can either unmute yourself or pop on, raise your hand. Everybody's going to be quiet today. Let me just check Facebook real quick.
In that case, MC.
So we have a few comments on.
Facebook real quick.
So does anybody have any questions or comments about this? I know some people have just hopped on, so if you have additional questions,
Or if they want to type it into the chat, like
yeah,
feel free to type it into the chat, either here or on Facebook. We will look.
Thanks, Leona. See, I'm so out of practice on these calls. I haven't been on one in so long.
Well, we're really grateful that you came, because this is, something that people have been asking a lot about. So hopefully they'll take this opportunity between next week and this week to ask questions.
Yeah. So the other thing that I did pull up, I'm going to share. Let me just stop sharing my screen. I can figure out how to do that. I did pull up the statute, the actual statute that I wanted to share.
While you're pulling that up, though, can I just read you a question from Facebook?
Yeah, go for it.
It says, can the school deny my request for my son not to graduate?
Can read that again? I'm sorry.
Charlene asks, can the school deny my request for my son not to graduate?
So that is a complicated question to a degree. It's a PPT decision for a student to graduate. And so hopefully that conversation has happened at a PPT meeting. And if the district and the family do not agree, so a student, if a student is a person who has an IEP, then the PPT needs to look at whether or not that person is prepared for post-secondary education, employment, and independent living. And if that student is not prepared to move on, to receive a diploma and move on, then the IEP, they should be looking at the IEP and determining what else they need to be working on. And so at that point, they should not be receiving their diploma. They should not be graduating because they're not prepared. And so again, hopefully that discussion is happening at a PPT meeting, but I'm guessing because you're saying that, you're asking that question, that may not have happened, or there was disagreement there. And so that would be something that I would suggest. One, being clear that you disagree, making sure that it is reflected on the IEP, on the prior written notice page, page 3, that the family has requested that that person receive further education. And if you still don't agree, then I would suggest giving the CPAC office a call at 860-739-3089, or emailing us at cpac@cpacinc.org to discuss some of the specifics. Because some of the things you want to look at are things like, have they met their goals and objectives? And over the past couple of years, have they met their goals and objectives? Because sometimes we see goals and objectives that will drop off of the IEP, but they didn't necessarily master them. So there's many different things to look at around the question whether a student should be graduating. But there are lots of times that the school district will disagree with the family. So it's not like a yes or no answer as to whether they can deny that request. So I would suggest digging a little further into that with the CPAC consultant. And I hope that answers that question. And in the chat, oh yeah, and Lynn says also check the IEP to see what the exit criteria was. Yeah, so that's an important piece to look at as well. So I'm going to share the CPAC phone number. And I'm also going to share, so we're talking about the legislation that was put into effect in 2013, and I want to share the link to that.
Wait, Beth, you just sent that to me privately.
Oh, huh. I am so rusty on Zoom right now. It's like cracking me up. I'm really bad.
I'll put it in.
Thank you. Now, why am I sending it? Okay. Oh dear. My tech skills are bad today. That's really funny. Okay, and so we'll the legislation I'll hop over and put on Facebook as well. And then if you're on our Facebook page watching this, then you can certainly find that phone number. And our email address.
I'll put it over.
Oh, thank you. So are there any other questions on Facebook or anybody else? All right, well, thank you all for joining. Don't hesitate to reach out to us. Like I said, talk with a consultant. With transition, there's so many nuances to it that really talking with somebody that can help you sort of look at all of the pieces and figure out, are we doing everything we need to do? What do I need to look at? What if the school district and I disagree? It's just, there's so many different pieces to transition. And I also want to mention that we do have 4 transition to adult life webinars on our website. So certainly take a look at those. I talk about transition in the law, transition in the IEP, resources in Connecticut, and another one that I'm blanking on right now. I can't remember. And we're going to be doing transition to college with a person from one of the local schools who works in the disability services office. So, so stay tuned for that. And then I do have one note about the AR case in Connecticut. So for those of you who are not aware of that, there was a case filed several years ago that said that they were basically saying that students should receive services until they turn 22 through their 21st school year, because other services are provided to people. I believe adult education goes until age 22. And so the lawsuit was filed. AR was represented by Disability Rights CT, and the federal judge ruled, and the decision came down on June 10th that yes, indeed, students who receive special education services should be receiving an education through the age of 21 until the day before they turn 22. And so that has created a bit of a stir in Connecticut. And right now, as it stands, the state has appealed the decision. I think it was about a week and a half ago or so that the state appealed the decision. However, at this point, as it stands, when that decision came down, that became case law. And so what that means is if you have a student who is 21 and has been exited or will be exited, at this point, most of them have been exited, it's important to have a conversation with the school district. So that could be requesting a PPT meeting. And that is the suggestion at this point from the people that I have spoken with about this, is to, if you are a person, a parent or a person who falls into that category of being exited this year, aging out this year, I should say, I'm sorry, I said exited, I meant aging out, then you can request a PPT meeting. After June 30th, typically you don't have a right to a PPT meeting, but that's the first request. And then if that is denied, then call CPAC, have a conversation about what the next steps should be. There's a lot of misinformation going on around, whether or not districts are going to do this, not going to do this, whether the appeal does not require them to provide services at this point. As it's interpreted right now, that's not what it means. It means that they are required. The appeal was not, there's something called a stay that can be granted, which means that they don't have to provide the services. That was not granted by the judge. Ladies, is there anything else I should be saying? Yeah, hop in, Lynn.
Can I add to that?
Sure.
So I'm Lynn Rule. I'm also a parent consultant at the Connecticut Parent Advocacy Center. And I just want to add that as it relates to this particular case, services from, in the past, we referred to transition services as being from 18 to 21. And it went through that year that a child turned 21. So if their birthday was September, actually, if your child's birthday was July 2nd, then they got to receive, and they turned 21 July 2nd, they were entitled to receive transition services for that whole next school year, because it was for the school year of their 21st birthday. The difference with this case is that the stipulation here is that it goes to the day before your 22nd birthday. So using that same example, if your child turns 22 on July 2nd, their service, it wouldn't change, nothing would change. So if you have a child whose birthday is in like the late summer, early fall, that's really something you're going to want to consider as it relates to what exactly are you going to receive for additional services? What's the quality of that service going to be? How much of a service is that going to provide to your child? Because if school starts, say, the end of August and your child is only in school for 1 week, what are they actually achieving from this? What are they obtaining from this? So exiting them at 21, at the end of that school year may have been in their best interest. If your child's birthday is later, then most definitely they're going to be receiving services for an extended period of time, and it would provide more of an opportunity to them. So I think that's just a really important distinction to remember as it relates to that case. And yes, there have been, if you have also, if your child has turned 21 this past year and they would have aged out, if you did not take the diploma and have requested a PPT meeting, then that should be up for discussion. So I just wanted to add those 2 points.
Yeah, great. Thanks, Lynn. That's great clarification. So it's a conversation to have, especially for those that have birthdays, you know, sometime in this year. There's also that conversation about the possibility of compensatory services. And so, you know, would you be able to add something more for students in those cases? So let's just say that there are a lot of unknowns right now, a lot of challenges within what is happening, at all levels, really. We're seeing lots of challenges. I was on a call with some parent centers around the country today, and Connecticut's not alone. Most states are struggling in this as well. But if you have a child that falls into that, it's called a class. If you have a child that falls into that class, then definitely reach out to us. And we'll continue to share information because there is a class and there's a possibility that this could go back a couple of years. So kids that have had graduated, I can't remember exactly what did they say 5 years or
2014.
2014, okay. So it definitely could go back a ways. You know, what would you do for a student that has already been out for that many years? Actually, somebody asked me that and I said, well, you know, there are people that you can hire to do independent living skills and, you know, to do job coaches that you could hire to help a person, you know, learn some more skills. And so it's not like they would have to go back to school. It's never meant that. So keep an eye on our CPAC Facebook page, or if you would like to receive our newsletter, sign up for that. And we will, as this information comes out, we'll share it with people. So anything else, ladies, that you can think of? Were there any questions on Facebook, Fiona, that we missed? No?
No, there's no more questions. I think we answered what was there.
Okay, great. All right, well, if that's everything, I thank you all for joining us. Thank you, Lynn and Leona, for hopping on as well today. And our next call is Thursday at 3 o'clock. And is that Lisa and Leona?
Yep, it's Lisa and I will take whatever's on everybody's mind. And then, of course, Spanish tomorrow at 4 p.m.
Yep. No, Spanish is at 1.
Oh, at 1. I thought they switched to 4. Sorry.
Oh, wait.
Yeah,
should
I
check
thought she
that.
was switching.
Is
I
she
think
switched
they
to
switched
4?
to 4. Yeah.
Okay. I'm the last to know.
So
listen to them.
It just switched. It just switched. I
Okay.
swear.
All right. They know. They know. I don't know. All right. Thank you, everyone.
Thank you.
Have a great rest of the day.
Bye.
Bye.